Okay. It appears maybe that we are alive. Alive. Live. So we are going to be talking about peg leg finance. Oh, great. So he's a licensed attorney, attorney licensed to practice law in the state of Utah. He has undergone undergraduate and graduate on this channel, and we're looking at legal issues, sovereign citizens, and finance. What a combo. I'm a believer in value investing, and as you might have guessed from my channel name, I am above knee amputee. Well, I mean, I know what a peg leg is, but I guess I was just thinking or hoping something different. Okie dokie. So we will be going over his review of Mr. DeCastro Delete Laws himself.
We're back. Again.
Oh, great.
Already. I thought we'd have at least one day of a break from Delete Laws.
Well, you could have just not covered it.
I didn't think it would be more than a day because I did expect 24 and 23 out of order.
Not only they out of order, they
showed
freaking
up on the 14th, even though
shit's not there.
The 13th.
Isn't that amazing?
Although the clerk entered them on the 14th.
There we go.
So that's a little annoying to my brain.
Oh, it's more than annoying, dude.
That's what we're looking at. So
what are we looking at?
What is it that we are looking at out of order?
Court corruption.
First, we have like I said, it's out of order. So 23 here.
How'd that happen?
We have another filing from Mr. Jensen.
Yeah, that's a leave.
Motion for leave to file suggestions in opposition to defendant's motion to dismiss.
Oh, yeah.
And I've read it.
No, you haven't.
I don't know what that is.
That's because you haven't read it.
It's not something that exists in law. I mean,
what doesn't?
We remember from the Darrell Brooks trial. Is that lawful law? This isn't.
Is it?
And then,
how do you know?
Number 24, we have an order already from, this time, the magistrate judge, Elena Ucha, however you pronounce her name, on Jensen's motion for joinder, plaintiff's motion to stay, and motion for extraordinary writ of mandamus.
You are going to mention the fact that no judge can make any ruling on anything outside of the docket, right? Right? So, okay.
And it's denied. Surprise, surprise. And I'm just as amused as I am by all this. So, Mr. Jensen left a couple comments on yesterday's video, and his primary comment, he said, read the case law. And
yeah, read the case law.
So here's some general life advice for Mr. Jensen. When you are the one who is making extraordinary claims,
yeah, but first you have to get it into the docket, don't you? Oh joy, look at this. Unable to render code block, huh? This used to work. Well, hell, let's just do one of those. That's not what I was looking for. Why did I put that in there? Motion. Notice of appeal. Here we go. Let's see what's in here. Notice this didn't get filed either. Probably a good thing, because I forgot to mention what court I was appealing to. Dude, and you can all read this. It's on GitHub. Okay. So, there's 2 notices of appeal. Look, I'm saying there's something missing from the docket. Missing, da-da-da, da-da-da-da. Oh, yeah, we don't want to do that. Let's see if we can get this open. Download raw file. Oh, come on. Okay. So now, what kind of magic do we have to do to override the... no, still opening in Adobe. That's wonderful. Let's try one of those. Oh, there we go. So here is 46 pages. Does the docket have 46 pages? I don't think it does. So why are you talking about it? You know? And he's saying that there is no leave to file suggestions in opposition. Well, let's see. We have an intervener complaint. Oh, that's not in there anywhere. Let's see. We got partially supported and partially opposed Rule 24 motion to intervene. Let's see. Is that on there? No, that's not on there. So comes now intervener applicant Jason A. Jensen under Federal Rules of Civil Procedure 24A, or in the alternatively, I guess that was supposed to be alternative. Federal Rules of Civil Procedure 24B. So one is an intervention by right, and another one is an intervention by permission. Jensen received Mr. DeCastro's positive consent on filing this motion to intervene on June 12th at 10:44 a.m. Central Standard Time. Jensen received defendant's refusal to consent to file this motion to intervene on June 12th, 2023 at 11:01 a.m. Defendants do not believe that the driver and traffic stop detainee has any Miranda rights, and or that those Miranda rights are implicated by the policy exhibited by isolation of the traffic stop detained driver. Jensen is a licensed motor vehicle operator in the United States. Jensen has prerogative in the state of Nevada and other southern warm states as a snowbird with a motor home to enjoy varied climates. Jensen lives in and utilizes his mobile living arrangement to offset discrimination of the mentally ill. This allows Jensen to relocate when prejudice and conflict arises when neurotypical persons identify Jensen's mental health disorders. Mr. Jose de Castro cannot, as the other party to a traffic stop, to the scenario presented in this case, protect and enforce Miranda law as prescribed in the Supreme Court of the United States of America, Berkemmer v. McCarthy, 468 U.S. 420, 1984 case. The defendant's motion to dismiss violates Federal Rules of Civil Procedure 8 as an affirmative defense, such as qualified immunity is a responsive pleading and not a motion. This goes way back into how the Supreme Court converted good faith immunity defenses, which were an affirmative defense. Oh, yeah. And this is how you know it's an affirmative defense, because your defense is basically like, oh, yes, I did that thing, but for this. Okay, so you're not denying that you did the thing. What you're denying is that you should be responsible for the thing. That's the affirmative defense. So qualified immunity is like a big, and you'd have to get into that case that I was showing. This gets into qualified immunity, and it talks about how it converted all these different things, all these affirmative defense immunities. So this case is out of the United States Court of Appeals for the Fifth Circuit, and it is case number 21-2200. And the opinion that I was talking about was this one here, written by Don R. Willett, and he talks about the qualified immunity doctrine as flawed, foundationally from inception. That's what a judge wrote. Okay, so that's what I'm saying right here. And Jensen incorporates all elements and arguments in the attached proposed intervenor complaint as if it were a memorandum in support of this motion. Okay, we have an intervenor complaint. Does he show that? Let's see, there's a motion, there's an order, there's a motion, and there's a motion. Joiner, motion, suggestions and opposition. Order, Jensen's. So the order came in before the docket was hit, is what happened. That's how this happened, I think. But the numbers are weird. But there's no intervenor complaint, and there is no motion to intervene. There definitely isn't a motion for informa pauperis. Okay. So this is an application to proceed in district court without prepaying fees or costs. It's called an informa pauperis motion. So that's definitely not there. Okay, so what do I say? This is a wrongful arrest, excessive law, blah blah blah. The Fourth Amendment. I think I took this straight out of their filings, and then the parties, like right here, I say amended complaint verbatim. So I copied this. I just added myself as a party, jurisdictional and venue. Factual allegations. So I copied most of this from what they said, and I highlighted some stuff. At no time declaration of or evidence the subject of that stop being afforded any Miranda warnings. Allegedly approached the traffic stop and began recording and talking to the traffic detainee. And then the rest of this is right out of their crap. Otherwise, I would have bolded it if it was at all important. Legal discussion. The traffic stop and inquiry must be reasonably related to the scope to the justification for their initiation. Okay? And that's quoting Terry v. Ohio, but it's actually in this Berkmeyer versus McCarthy. Typically, this means that the officer may ask the detainee a moderate number of questions to determine his identity and try to obtain information confirming or dispelling the officer's suspicions. But the detainee is not obliged to respond. That's very important. If the detainee isn't obliged to respond, then the police have no authority to monopolize that person. Because if the police can say, listen, you're my traffic stop, bitch. You can't talk to anybody else until we're done here. Then he is obliged to respond. That would make that obligation. So let's see what obliged means. Obliged. To make somebody legally or morally bound to an action or course of action. So that's what I'm saying. When you isolate a person, they can't talk to anybody else, you've legally bound them to an action. You have to respond and answer my questions. And unless the detainee's answers provide the officer with probable cause to arrest him, he must then be released. The comparatively non-threatening character of detention of this sort explains the absence of any suggestion in our opinions that Terry stops are subject to the dictates of Miranda. And that's what they're saying. The non-coercive aspect of the ordinary traffic stop prompts us to hold that persons temporarily detained pursuant to such stop are not in custody for the purposes of Miranda. Well, that's what they're trying to change. They want to have their cake and they want to eat it too. They want to say, oh, well, you're not really, interrogatively detained. You're just this traffic roadside stop, but, no one else is allowed to talk to you. We're going to create this big bubble around the traffic stop. That's the scene. You're not allowed on the scene. Anybody with a camera, that's criminal because you're interfering, right? So they're creating that interrogative environment, but they're just doing it alongside the road. And that was why I wanted to intervene. It is settled that the safeguards prescribed by Miranda become applicable as soon as the suspect's freedom of action is curtailed to a degree associated with formal arrest. Okay, well, if I'm just detained on the side of the road, why can't I talk to some guy walking by? What's wrong with that? What? You want to know my name and my driver's license, registration, proof of insurance? You got all that. So why can't I bullshit with homeboy that's walking by? No, you're interfering. Well, interfering with what? Well, you're interfering with the officer's attempt to isolate and control the environment, right? So that starts creating that formal arrest. As soon as the suspect's freedom of action is curtailed to a degree associated with formal arrest. A motorist who has been detained pursuant to a traffic stop thereafter is subjected to treatment that renders him in custody for practical purposes. Right there. He will be entitled to the full penalty. I have a speech impediment. I know what that word is. I just can't pronounce it. Of protections prescribed by Miranda. Okay, but that's not what they're doing, right? They are escalating the environment. Nobody's allowed around for officer safety, not to control the environment, just officer safety. We have these officers that fear anybody with a camera, or they may not fear anybody else walking by, because the guy with the camera shows intent to do what? Intent of what? The document. So just because he seems antithetical to the police prerogative, he's a threat. Nor do other aspects of the interaction of Williams and the respondent support the contention that respondent was exposed to custodial interrogations at the scene of the stop. Berkheimer versus McCarthy. So, it's all, I took all this stuff right from one Supreme Court case that is still good precedence. It was the compulsive aspect of custodial interrogations, not the strength or the content of the government's suspicions at the time of the questioning was conducted. So that's what they're saying. No one else gets to talk to this person. This person isn't free to go until I get the answers that I want answered. That's exactly what they say. Well, we'll be here all day. Why, you don't want to answer, and then you're going to get charged with disorderly conduct and failure to obey and inhibiting my governmental operations by not answering my questions. That's exactly what they're doing, is they're making the traffic stop and the questions compulsive. And they're turning it into a custodial interrogation. Moreover, the typical traffic stop is conducted in public, and the atmosphere surrounding it is substantially less police-dominated, well, not anymore, than the surroundings of the kind of interrogation at issue in Miranda and subsequent cases in which Miranda has been applied. Well, that's not true anymore. Right? I mean, a traffic stop now is the first thing they do is pull up behind you. If it's nighttime, they make you completely blind by shining a light so they can see everything that's going on. You can't see shit. That's not true anymore. However, if a motorist who has been detained pursuant to a traffic stop thereafter is subject... Well, I copied this. Same thing as above, I guess. To be sure, the aura of authority surrounding an armed, uniformed officer and the knowledge that the officer has some discretion in deciding whether to issue a citation in combination exert some pressure on the detainee to respond to questions, but some pressure on the detainee. And what they're saying is, you're going to get a citation or not. That's the exert some pressure. That's just a little bit of pressure. But that's not what they're doing anymore. Now they're doing this psychological assault. And then all of a sudden you're isolated and you can't talk to nobody else and all this other shit. But other aspects of the situation substantially offset these forces. Listen to this. This is the Supreme Court of the United States. Perhaps most importantly. Well, gee, what does that mean? Most importantly. What is the most importantly? And what does perhaps mean? Well, perhaps is a non-definitive language, but what they're saying is most likely the most important part of this element is the typical traffic stop is public, yes, at least to some degree. Passersby on foot or in other cars witness the interaction of the officer and motorist. What does witness mean? Well, of course I wanted to find out about a 19-something movie. A person who sees an event, typically a crime or accident, take place. That's interesting. It just says sees, because there's a lot of times when witnesses testify to noises and what they heard, screams. So that's an interesting way of putting it. And just by claiming, police safety, we even know who DeCastro is. We have to deal with him constantly, but we don't know. He could be dangerous. However, Mr. DeCastro's behavior, conversing with and being nearby and recording the interactions, this is the exact kind of negating force Berkheimer held most importantly negated the Miranda requirements of a traffic stop detainee. If the policy of the Las Vegas Metropolitan Police Department has a policy of creating a buffer or crime scene and monopolizing the attention, the ability and ability for a traffic detainee, and charging anyone close enough to hear the conversations and provide the counterbalance to the state's interrogation, then the driver is entitled to Miranda warnings. All the defendants have been made aware of these clearly established rights since Berkheimer in 1984, some 39 years. In arguendo, officer safety, creating a crime scene around a traffic stop does not protect the officers. Any person seeking to harm the police need only drive around looking for a traffic stop and then pull up and engage the officer in surprise. Okay, so it's a stupid argument, but somehow anytime the police say officer safety, it's a blank check to do anything you want. So then I incorporate those paragraphs, and then I make a statement. I have one claim, not asking for any money, and then I had filed a motion to strike, and I filed a motion to join her. Now I think this one was actually put in there. Yeah, I think this one was put in there, but see, this rested on, you know, the whole claim of intervention, and maybe that's not right. You know, all you got to do is find your rights in those 200 billion letters of law. Yeah, so this is the document that I filed, right or wrong, whatever. But that's not what's in there. All this, I got 46 pages here. And this is specifically on the sovereignty part. So let's see. Jensen's suggestions in opposition. So this is the part he's going to read. This right here. Right there. And he's going to be like, it don't make any sense. It doesn't make any sense. Well, that's because the fucking suggestions in opposition are not there. Comes now, intervener plaintiff Jason A. Jensen with the following suggestions in opposition to defendant's motion to dismiss. Qualified immunity and affirmative defense, originally referred to as good faith immunity, is an element of sovereignty. That Harlow completely reformulated qualified immunity along principles not at all embodied in the common law, blah, 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 was reinforced. Mitchell held that Harlow established an immunity from suit rather than a mere defense to liability, which is more like absolute immunity, is effectively lost if a case is erroneously permitted to go to trial. Thus, we held in Mitchell that the denial of qualified has that. Only the state has this authority. And it's all bullshit. It's all bullshit. It sounded good, so we made some shit up. Second, the court held that while immunity for private parties is not derived from official immunity, is based on the important public interest, blah, 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 blah. Section 1983 creates a species of tort liability that on its face admits no immunities. Not only that, the 16 missing words specifically removed those immunities. Nonetheless, we have accorded that certain government officials either absolute or qualified immunity. So normally, you know, the letter of the law. So if Congress wanted to do that or did this or that, they would have said that. But what the Supreme Court has said is that you can seek damages for violation of your rights, except for not really. I used to test things. They didn't sell you crap that didn't ever work. I mean, I've had Bluetooth. I can't maintain a